criminal confession. This is the death knell to the defense of almost any case, at least in the eyes of most lawyers. But we actually had a case that we won after a jury trial after only 30 minutes of deliberation, in which case our client confessed to owning a firearm that had been stolen from a police officer. He was charged with 3 felony counts: receiving stolen property, possession of a firearm while loaded, and he was facing serious minimum mandatory jail time. So Ryan, how did we do it?
So what we did it by being creative. We went in with what's called a necessity defense. We argued that because our client had previously witnessed a robbery, was subjected to repeated violence, that he wasn't assisted by the police in those situations, that he needed a gun for his protection. But more so is we didn't just decide, let's go with one strategy and see what happens. What we do is we try to figure out everything that we possibly can to represent our clients effectively and then make a good argument. And so here, we were ultimately able to make an argument that the prosecutor couldn't prove that our client's confession was true. And as a result of that, the jury very quickly acquitted him.
A difficult task, and not one that many lawyers are equipped to handle, but something that Ryan and I were able to put together for our client. I think a lot of lawyers would think, well gee, the police say that my client confessed. How am I going to confront that evidence? The problem is that most lawyers are afraid to even try. They're just going to assume that there's nothing they can do for their client. But what Ryan and I do is we do everything in our power to avoid the risks that our clients face and to provide them a truly remarkable defense. Where every other lawyer, I think, would have shied away from putting this case on for trial, Ryan and I did not shy away. We put the government to its test. Ryan, I want to talk briefly about the concept of what happened with the necessity defense and how we were ultimately able to pivot and move toward a defense that the so-called confession of our client was not enough to prove that our client was guilty. We're putting forward this necessity defense. Suddenly it's taken out from under us. Most lawyers are going to fall apart and crawl into a cave to die. How is it that this defense was taken away from our client, and how is it that we responded agilely enough to still get an acquittal?
So a large part about that is that the reason that we work good as a partnership is that we don't rely upon scripts for anything, including what we're saying right now. And that's what we did in this case, is we talked about how we were going to approach this subject. The defense that we ultimately relied on in our closing argument is not one that we just figured out on the spot. It's one that we talked about and vetted as a real potential option. But we were faced with some real clear evidence. Our client was shot, and then the police found a gun inside of his mother's car. A necessity defense cried out. He needed that gun for his own protection. There was no question there. When the judge ultimately disagreed with that, fine. We went to another argument that they couldn't prove that his confession was voluntary. In addition, that even if they did, that the police, for whatever reason, decided not to ask the passenger of the car, the owner of the car, the suspects that went inside of the car after shooting our client, what about that gun? And it was ultimately the failure of the police to investigate that we were able to argue to the jury that they should latch onto and find our client not guilty.
Right. Things that really can only be accomplished through vigorous and meticulous cross-examination. Witness after witness was paraded into court. None of them were prepared for what our questions were going to be. Their theory of the case that the confession was enough didn't withstand scrutiny. A 2-day trial, 30 minutes of jury deliberations, and a thumbs up from the foreman to the jury to the defendant's mother, who got to bring her son home that night when she was afraid that she wouldn't see him for many years while he was in. Even if it seems like all hope is lost, even if another lawyer tells you that there's no way to fight the evidence, come to our office and we'll talk about some creative solutions for you.
We have a history of winning.